variety of commercial and transactional type work. But one of the things that I focus on is working with physicians to help them negotiate their employment agreements. I do a lot of work with folks that are early in their careers. Our firm has a residents and fellows program that gives a capped rate for folks who are early in their career and really starting to learn to navigate this process. So I work with a lot of people, residents and fellows, as well as their friends who are 1 to 5 years out of practice, or when they come back a few years later and want to move to a new location. So I'm hoping that I can provide some insights for you as you're starting to navigate this process, because while I think it's really important to have an attorney there to actually negotiate your employment agreement, I think it's really important to understand some of these really big ticket concepts, so that when you're doing your interviewing, or when you're starting to discuss your letters of intent or offer letters, that you really know some of the legal concepts that you should be thinking about. Because from my perspective, I think the legal terms should really be part of the consideration when you're deciding what opportunity is best for you. So I guess I just want to start off. I want to give a little bit of a primer on the contracts review process. If this is something that you haven't been involved with before, it's good to kind of have an idea about what it's like and what you should really be focusing on. And then I'm going to go through some of the key items that you're going to be considering when you're looking at offers or employment agreements. And those things are compensation, non-compete provisions, professional liability or malpractice insurance, term and termination, and a few other things that I tend to see pretty frequently, and that are the concerns of my clients. So the first thing I just wanted to talk about is the process. It's funny because working with all residents and fellows, you would be surprised how often, and it actually happened today, where someone will say to me, I'm a very smart person. I've spent so many years going through medical school and residency, and I take a look at this contract and I have no idea what it means. All of this is foreign to me. Literally, somebody said this to me today. And so I think a big part of this is really starting to understand what the concepts are, like I said, and what you should be thinking about. So I think whenever I talk with clients, that's the first thing that we do. We run through all of the contract. We talk about what each provision means and why it's important to you. And then usually I'm trying to get a good understanding about what my client's really focus is. And so that I can not only provide basically standard comments that I give to anyone else, but something that's really a little bit more focused on them. And so I think that takes it to sort of the second part, which is, I think contract review and the process, especially early on in your career, involves a lot of personal reflection. You are going to have some negotiating power earlier in your career, I think more than a lot of people expect. But a lot of what happens too is trying to figure out, well, if I can either get a better non-compete or more salary, what's more important for me? So I think that's part of what this process has to be, is relying on your attorney who has experience in this area to navigate what is important to you, and where you can really make progress in your employment agreements. And then I think the third thing, and what I think everyone expects their attorney to provide, is negotiation. It's sort of interesting. I do a lot of different types of agreements in a lot of different areas of law, and the negotiation in employment agreements for physicians is a little bit strange, because there's sort of the expectation that the physician is the go-between. They don't really like to introduce me to their attorneys. And so there's a lot of negotiation that's going to come on, and me really helping you to advocate for yourself. I'm always happy to redline agreements, which means mark things up, but usually hospitals and practices don't like that. So a lot of it is providing the physician with the arguments that they need to make in order to get the hospital to practice to incorporate some changes into the document. So really what the process tends to be is that you'll go through your interviews, and you'll have a couple of different offers out on the table usually. What you want to do is try to keep a few of those in hand as long as possible. A lot of people like to identify one opportunity that they're focused on and really move forward only with that one. But that really narrows negotiating leverage, and really, even in your own mind, if you know that you are only going for this one position, you're often a lot more willing to give things up because you've already really narrowed in on that one. So I think one of the things I usually try to recommend is to keep at least 2 options running as long as possible, just to make sure that you're really pushing for the things that you need and you have a fallback plan if things don't fall through with your number one choice. So the second thing, after you go through the interview process, the next step is the letter of intent or offer letter stage, where you'll get a pretty simple written document from the hospital or the practice that outlines the key terms. So it's things like, always it's salary, sometimes it's signing this, occasionally it's non-compete. It's really some of the big ticket items. A lot of times folks are going to want to just, the physicians are going to want to just sign these, send them back, and then hand to their attorney afterwards to deal with negotiation. And I always recommend against doing that. It's really helpful for me when a physician will get me engaged at the offer letter stage, because what I always say is they don't have to include everything that you want. You have to agree with everything that they include. So always at the end of these offer letters, it's going to say this is non-binding. And that's because you're going to go to the next stage, which is negotiating the employment agreement. But the problem is that when I go to try to negotiate one of these points, like a salary down the line, what I hear back from the hospital is, well, I understand that the terms in the offer letter weren't binding, but only move forward to the employment agreement stage because your client agreed to a salary of X. So what it really helps is for me to be able to talk with my client at the offer letter stage. Let's negotiate things like salary and those big ticket items are there so that we don't handcuff ourselves when it comes down to the employment agreement stage. So then after we go through that, after the offer letter, we will normally move on to the employment agreement stage. And what happens there is that they'll provide you a document. Generally, I will provide some comments that you send over to the other side. And there's a lot of back and forth, redlining of agreements. People usually ask me what the timeline is on that. And it really depends on the other side. I would say usually a few months in order to negotiate an employment agreement, but it really depends on how contentious it is. And the further you are along in your practice, the more years you have under your belt, the longer it's going to take, because it's going to be a lot more, there's going to be a lot more issues that we have to work through. And Eileen, did we decide how we were handling questions? Were we holding them to the end, or?
I think however you want to do it. If you want to stop and ask questions as we go through, that's completely fine. We have a small enough group too, so if anyone has a question, feel free to raise your hand, and we'll get that question for you.
Yeah, I think that would be helpful instead of just having me continue to go and take everything. Okay. If anyone has any questions on sort of the process in general, I'd be happy to answer those. And also I can circle back. Okay, so I'm just going to move on, and I'll sort of stop after every category if anyone has any questions that they want to bring up in that time frame. So, sorry about that. My screen keeps freezing. Obviously, compensation is going to be one of the first things that people want to talk about. If you're earlier in your career, you likely have a lot of debt that you've got to deal with, and so understanding what each of these employers is going to pay you is usually the number one concern. Compensation is generally broken into 3 buckets. First one being base compensation, the second one being incentive compensation, and the third one being one-time bonuses. All of these are important, and there's some variations on them, which I can go through now. So the first thing is base compensation. That's going to be your salary that you see on your every couple weeks, every 2 weeks, or every monthly paycheck. Usually people are asking me kind of to get an idea about, is this reasonable? Is this market? And a lot of that, I think, a lot of the best information that you get about salary comes from other offers. So again, that's a lot of the reason why having a few offers in hand is really helpful, because what's reasonable varies from region to region. It varies on type of employer, and there are some national resources that we can use. So, oh my gosh, I'm blanking on the name of the resource right now. It's on at the end of my presentation. So there is a good resource that we often use that gives good comparability of the MGMA, that gives good comparability data based on things like the type of specialty you have, what kind of percentile you were, and it really gives some fairly good baselines. But particularly right now, I think the last year has shown some real volatility in compensation because of staffing shortages. And so I found the data pretty recently to be a little stale. So really it is those other offers and talking with your colleagues that really give you a good understanding about what compensation would be. This is probably, I think, the best time that I've had in my 6 years of reviewing these contracts for negotiating salary. I feel like physicians are in a good place right now to try to increase their salaries, and so we are being pretty effective at increasing those the offers that folks are getting, either in just increasing the base that you're getting for the first initial term of your agreement, or for putting in things like escalations. And so that's some of the things that I mark in things you should be thinking about. It's not just the original number. Is there an escalation? With the inflation rate what it is, I've been liking to see and have been successful getting base salaries that increase in year 2 and year 3 automatically, as opposed to having to wait to the end of the term. So you can either see that as a dollar value, as a percentage, or as a built-in cost of living increase. So particularly right now, I think that's a pretty important thing to be thinking about with respect to base compensation. The second thing to think about is, does the employer have the ability to revise your compensation? A lot of agreements will have some sneaky language in there that says, we're going to pay you $300,000, but we have the ability to revise your compensation at any time. So knowing to look for that language is really important, because I think that came up a lot in COVID, where maybe there was not a need for some of the physicians. And so practices were using sort of inventive ways to reduce compensation of their physicians, or to furlough, delay, put people on leave or terminate them. So think about if the agreement gives the hospital the ability to revise your compensation. And the third thing is, we'll talk a little bit about incentive compensation next, but I usually advise people to think about, is your base compensation sufficient if you're not able to achieve your objectives? And I think this comes into play most when we've got more subjective incentives, which we'll talk about, but really think about it in the context of, your base is the thing that you get paid day in and day out. You want to make sure that that is sufficient for you. So the next thing to talk about is incentive compensation. There's lots of different ways that these can be structured, but really I think they fall into 3 main categories. The first one is the traditional way that incentive comp is structured, and that is a collections or RVU basis. So usually the employer will set a target number of RVUs that you have to achieve in a year, and you'll get a certain bonus amount. That was really the way that I think 10 years ago, almost all incentive comp plans were structured. I think that is less the case now. There is sort of this transition from these productivity and RVU based incentives to other structures, but we still do see them a lot. And I think whenever you're considering a job that has an RVU structure, it's really important to have them provide information about attainability. So, one RVU in one place is not necessarily the same as it is somewhere else. What is counted? Is it only personally performed services? Does it include ancillary services, other revenue sources? So what I usually recommend is to talk to them and have them provide examples of how other physicians similarly situated to you have achieved. Have they hit their RVU targets? Have they exceeded them? What are some actual numbers on how people have performed on this incentive comp plan? Because I think elsewise, MGMA does provide some baselines for what you can expect for RVUs, but it is so different, I think, from employer to employer, that I really usually advise my clients to really have a conversation and ask for some hard numbers around attainability. The second type is a profits type incentive plan. I would say I see this normally more in private practices, and it's sort of, a bonus based on the revenue generally that you bring in, although sometimes it can be a pooled revenue, less overhead, and that's how your bonus will be determined. The last one is the one I think is becoming a little bit more popular with new value-based systems, and those are discretionary or quality bonuses. And so these are the bonuses which tend to be of lower dollar value than an RVU bonus, and they tend to be structured with subjective criteria. So you've completed all of your reporting on a timely basis. You have attended all the meetings that you have to attend, those types of things. And we're seeing those a lot more. I think what my concern as an attorney generally is with those type of bonuses are subjectivity is great, but it's also not great, because you want to make sure you have some sort of way to determine that if you've done your job, you will be able to get your bonus. And also, I think there tends to be a lot of language in these types of bonus programs that make them more discretionary than the practices will represent to the candidate. So I think, these are the ones that I would particularly say, make sure that you are comfortable with your base salary, because while they will tell you that they have always paid these out, I always tend to be a little bit cautious and try to make sure the language is a little tighter here. And the third type of compensation that you want to think about at this point in your career are one-time bonuses. They are probably most prevalent at this level, and my understanding from the agreements that I've been seeing recently are they have been fairly aggressive recently at providing things, particularly like sign-on bonuses. So the different types of one-time bonuses that you should be thinking about at this point in your career are signing bonuses, retention bonuses, and moving expense reimbursements. So signing bonuses are the bonus that you'd receive at the beginning of your employment. Generally, they're not paid when you sign your agreement. Normally, you're going to sign your agreement like 9 months before your actual work starts. Most employers are going to wait to pay you until you actually start working, which makes signing bonus a little bit of a misnomer. But these are going to be the bonuses that you're paid at the beginning of your employment. The second one is a retention bonus. I probably see these less frequently, but occasionally we do. And these are bonuses. Instead of front loading the bonus, the employers want to incentivize you to stay on for the whole term of your agreement. And so instead of giving you a big signing bonus at the beginning, they'll give you, a moderate sign-on bonus, for example, in year 2 and year 3 of your contract, as an incentive to keep you here. And the third thing is moving expense reimbursements. These are normally outlined in policies more than they are in your agreement, but it's going to be a reimbursement. So you've got to usually provide receipts, and they'll pay up to $10,000, for example, of moving expenses to come to your new location. Excuse me. So a few things to think about when you're thinking about one-time bonuses. Obviously, the amounts. Again, like having a couple different offers is helpful for that. MGMA has information about that. I, as an experienced practitioner, tend to have an idea about that. But again, particularly like I said, with the base compensation over the last year, the numbers are really all over the place. And particularly in areas that are underserved, they tend to be getting a little bit bigger. So obviously the amount is important. The second thing is timing of payment. Like I mentioned, it's generally not when you sign your agreement, although I have had the ability to negotiate that if it is important to you. The next thing is repayment obligations, and I think these are really important. So normally, particularly with the signing bonuses, there's going to be an obligation that you repay them if you leave prior to the end of the initial term of your agreement. And we'll talk about this a little bit later, but generally a first contract or an early career contract will be 3 years, occasionally 2, occasionally a little bit more. But that's really the time frame that they're looking for you to invest in working for them. And so what they are looking for is, in exchange for your $40,000 signing bonus, you need to stay for the full first 3 years of your agreement. And how they'll do that is to structure repayment obligations. So how they mostly work is a month by month sort of forgiveness of the obligation. So if I have an initial term of 3 years and my sign-on bonus is $30,000 and I leave after a year, usually the repayment obligation is I'll have to repay 2/3 of that bonus. So, I occasionally I do have ones that'll require you to repay the full thing if you leave at any point in the initial term, but generally what you're looking for and what is probably fair and reasonable, and what a lot of employers do is to have that prorated by month repayment obligation. And the second thing that I note is just to look out for weird things with bonuses. I had one of these that I was looking at today where it's called a signing bonus, but how it's structured is a promissory note where I give you $30,000, you owe it back to me on a promissory note, kind of like a loan. And every month you stay, I forgive a little bit of this debt. And that it's sort of a complicated structure. And, I with this example, I have sort of told this physician to see if they're interested in other opportunities, and then we really need to negotiate if that's the way it is. Because, there's questions of things about when is the note forgiven? If I terminate the contract because you've done something wrong, is the note forgiven? And in this agreement, it didn't say that. So there's a lot of tricks depending on if it's not, a lot of things that you need to think about if it's not a straightforward signing bonus that comes $30,000 at the day I sign and that's it. So that's all I had on compensation. I don't know if anyone has questions, anything I can cover on that in a little more detail. Okay. So I'll move on to non-compete provisions. After we talk about the money. Oh, go ahead.
I'm sorry. I do have a couple questions coming through the chat.
Yeah,
so here's one. At what point does salary negotiation take place? I have a term sheet and have been asked to give verbal or informal intent. Do I ask to negotiate compensation now or after the contract has been written up?
So I would negotiate it now. That's one of those terms again. If you have the term sheet, you want to agree with everything that it says. So if you don't agree with the salary, let's negotiate it now, is usually my advice.
And then a second question, is the repaid amount of a signing bonus the exact amount or is it plus interest?
It's usually the exact amount. The note situation has an interest component to it, but most of the time it's going to be the exact amount.
Any other questions? That's all I see in the chat right now.
Great, thank you. Okay, so the next sort of big topic that we usually talk about are non-compete provisions. So this is the provision that generally says how you're going to be restricted from practice after you leave employment with this person. This is always sort of a hard one, I think, for early career physicians to want to negotiate because they feel like it makes them look like they're looking at the end of the employment relationship when they're just getting started. I can't tell you how many people have said to me, I don't want them to think that I'm not serious about this position. And if I'm talking about how I'm going to leave, they're going to think I'm not serious, which is not the case. Employers expect you to negotiate your agreement. They are not surprised when you get an attorney involved, and I don't think that they're ever really offended when you ask for things. And so non-compete is something that we definitely want to talk about because it says what your life is going to look like when you leave. From an employer's perspective, the non-compete's important because it helps them to keep their business relationships protected from, competition from you when you leave. They don't want you to leave and take all of your patients elsewhere or help a new employer to compete against them. And there's a couple different things that we always look at when we're looking at a non-compete. And the three key things are time period, geographic scope, and prohibited activities. So as far as time period, what time are we talking about? Generally, a non-compete, particularly in an early career agreement, is going to last 1 to 2 years after you leave employment with the employer. I would say 2/3 of them are 2 years. I'm always pushing for 1. So that's generally the time period that we're looking for. Just 1 second. I'm reminding myself if I had detail on further scope, and I did. That's okay though. The second thing that we always look at is the geographic scope of a non-compete. So where are you prohibited from being employed or from acting? And usually it's going to be a certain number of miles. People always ask me what's normal and reasonable. And that is really a fact-specific question, and it depends on where you're practicing. So what is going to be reasonable on a non-compete distance in Wyoming in the middle of nowhere is going to be very different than what is a reasonable distance in Manhattan. My general rule of thumb off the top of my head is 5 to 10 miles, but for example, Manhattan, that would be way too big, and Wyoming, that's probably way too small. So, talking through these things and where you're looking to practice with your attorney is going to be really important in making sure that you're not having too expansive of a non-compete. The other thing to look at when you're talking about geographic scope is where does that mileage run from? So does it only run from the locations and the offices of the practice where you actually provided services, or every location that they have? Because particularly if you're going to work for a large hospital system, if you've got 5 miles, but it's from every location that they have, that's going to be a really big distance. And so that's something that we usually want to talk about, is where that mileage is running from. And the last thing to think about is just what the prohibited activities are. Generally, they're going to be things like you're not going to be able to practice or be an owner in a practice or to help a practice basically compete with the employer. One question we get a lot is, are non-competes enforceable? So the general answer I'm going to say is yes, but it's a fact-specific question. So whether or not a non-compete is enforceable is a question of state law, and the way they are interpreted is very different from state to state. Some states have outright bans and don't allow non-competes at all. Some of them fine physicians to, some of them don't allow them for physicians because they are considered to be a job in the public interest. And others allow employers to really a lot more broad discretion. The general rules are they are enforceable if they are reasonably necessary to protect a legitimate business interest of an employer. And that could be things like they're protecting the goodwill that you have with their patients. They have provided you some sort of unique skill or training. And again, it's going to be fact specific and it's going to be different from state to state, but generally that's sort of the first element that you're looking for. The next one is, are the restrictions reasonably limited in duration and geographic scope? So those are things that we already talked about. And it's, how long is the non-compete? How broad is the geographic distance? Those things are all taken into consideration if you get into the point where you're in a dispute with your employer about whether you're violating your non-compete after you leave your employment. So what I mentioned before about, certain states not looking positively on non-competes for physicians, that's what's called the public policy exception. And a lot of courts will take the position where they don't want non-competes to be used just to eliminate competition. So really, when I'm looking at a contract on the front end, I'm trying to get the best agreement that I can get in place for my client. I want it to be as narrow as I possibly can make it. But the one thing I mention to my clients a lot of times is, if we've done the best that we can do here. But at the end of your employment, if it's not, if you potentially have a dispute with your employer about a violation of a non-compete, hire a really good local attorney. They're going to be able to look at the fact-specific cases in your jurisdiction and see if you can craft an argument about enforceability of your non-compete. People have asked a lot about, there's a new FTC rule that's out there that's looking to nationally regulate non-competes. And I linked in the PowerPoint, a few of my colleagues have just written an article about that. So the idea is that this rule would replace basically the state regulation of non-competes and be basically a federal ban on non-competes, as well as not only on new non-competes, but requiring employers to go back and revise already signed old non-competes. This is just at the rule phase. They're seeking comments at this point. Honestly, as a practitioner in this area, I don't really have high expectations that it's going to be implemented. My personal opinion is that the best outcome that this is going to have is to push the states to make change. It's going to be people pushing to make change on a state level, because there is a jurisdictional issue on whether the FTC actually has the ability to regulate non-competes on private companies. Again, a little different if it's government entities or non-competes, but I sort of doubt that this is going to have a huge impact on non-competes for everyone. The last thing is, how are non-competes enforced, which I think is important to think about. And I have a colleague who always describes it as they abolished slavery a long time ago. They can't make you work. But what they can do is make a claim against you for damages. So for example, if they have to pay locums to cover, or if they've lost out, they can quantify the damages of you competing. They'll make those claims against you. Some contracts will have what are called liquidated damages. And that's an amount that's agreed upon when you sign your contract that says, if I violate my non-compete, or if I want to violate my non-compete, I can pay, X amount of dollars, usually tied to an annual salary, in order to get out of your non-compete. Again, if you see something like that in an agreement, that's one of those red flag things that you definitely want to get a lawyer to look at, because you're basically agreeing upfront to an amount that you'd pay to get out of your non-compete. So that's something you should definitely be familiar with and understand. I already talked about some of these potential negotiations, but when we're talking about what the time period is, particularly if it's that 1 or 2 years, think about what your initial term is. So if we're talking about what's reasonable, it may be reasonable to have a 2-year non-compete on a 3 to 5 year initial term agreement. But if you're signing a 1-year agreement, you potentially have a 2-year non-compete, for example, that's not going to be really reasonable. And I actually have one of those right now too. May be different based on whether you're only going to be a part-time person or a full-time person. One of the things I usually try to get is some exceptions to the applicability of a non-compete based on why you're leaving employment. So if they've just terminated you for no reason, I always try to get that out of applicability of a non-compete. Or if you've terminated the agreement because of something they've done wrong, so they haven't paid you, you really shouldn't be subject to that non-compete. Also, sometimes I'll have clients that'll try to carve out non-competitive types of practice. So if you are in a private practice, we'll carve out from the non-compete going to academia, or something that really does not compete at all with the provider, so that at the front end that you've got options after this employment that aren't going to be in violation of the non-compete. And there's just going to be some other restrictive covenants that you'll generally see in agreement. And the other big one is non-solicitation. So there's generally 2 types, and they are non-solicitation of other employees and of patients. And these provisions try to keep you from going out and raiding your employer when you leave. Again, generally they're the 1 to 2 year period that aligns with your non-compete. And it's, I won't go out and solicit other employees to come to my new employer. I won't go out and, solicit my patients to come to my new employer. So you'll see those even in states where you don't have non-competes. Oftentimes you'll see non-solicitations because they're generally seen as having protecting a more reasonable, legitimate business interests of the employer. And I think that's all I had on non-competes, if anyone has questions.
There is a question in the chat that I missed about compensation. So we can start with that one. Monica asked, is the verbiage or actual ask for higher salary something that you can help with?
Yeah, I can definitely, I help all the time craft those arguments. Again, it's sort of fact specific. So a lot of times the most effective way to craft that is, I have other offers that are in this range. I really like this position, and this is where I need it to be. Other times it's, I think this is below market. So yeah, we work on that language all the time. Or, like I said, I've been doing a lot of, we're in an inflationary environment. The starting salary is okay, but we need to build in this XYZ. So yeah, your attorney should be able to help with that. Any other questions? Okay. Next thing is professional liability insurance. Really important. You want to make sure that your employer is responsible in your employment agreement and specifically says that they are responsible for providing professional liability insurance for you. Generally, that is not the problem. The bigger thing that I need to look at when I'm reviewing these policies is what type of policy is provided. So professional liability insurance is written two ways, and the way it is written determines what kinds of claims are made. So the first way that it can be written is on an occurrence basis, and an occurrence policy basically covers any claim that happened during the policy period, regardless of when the patient makes a claim, because it has occurred during the policy period. The other way that insurance policies can be written is on a claims made basis, and claims made policies provide a more limited coverage. So in order to be covered by a claims made policy, the actual event, so for example, a surgery, will have had to occur during the policy period, and the patient will have had to make the claim during the policy period. So if you, for example, perform a surgery during your employment and there's a problem, and the patient doesn't realize until 3 months after you've left your employment that there is a problem and makes a claim, that won't generally be covered by a claims made policy. And how you get the coverage that you need for claims made policy is that you get what's called a tail policy or an endorsement that covers that additional period. So what I always want to look at when I'm reading over insurance language in an employment agreement is, does it specify what type of policy is provided? If it says occurrence, generally that's a good sign. If it doesn't, I usually want them to specify what type of policy is provided. And if it's a claims made, I want to make sure that the employer is responsible for tail. That is generally a fair fight about who is responsible for tail. Some employers don't want any responsibility. Some will do things like link responsibility for tail to if you have stayed for your whole initial term of your employment agreement. Others will link payment of tail to you having left without having been terminated for cause. So there's a lot of ways that employers structure these provisions to pay, either not cover tail or only cover part of it. And it's it definitely, I work with a lot of OBGYNs, and it's incredibly important in that context because my understanding is their tail policies are very expensive. And so understanding what they are, really making sure it's not a vague provision and is clear on what the employer will be paying is really important with professional liability insurance. Any questions on professional liability insurance? Okay. The next thing I just wanted to talk about is term and termination. It sort of always seems like something that's a throwaway in your agreement, but it's important to look at what the term is in your agreement. I think I already mentioned generally early career contracts are in the 3-year range, sometimes 2, sometimes a little bit longer. But you need to sort of figure out why that's important. So is the term important because it's tied to something like a repayment obligation on a bonus? Could the term be important because it locks you in on a salary until the initial term ends? You need to think about what happens after the initial term expires. Does the contract automatically renew? And I will say that most do. Or does it end and you've got to renegotiate with the employer after that period? If it's evergreen, which means it renews after the initial term, do you have the opportunity to change compensation, or does that presume that you're going to stay with that same compensation in the years after your initial term? So there's a lot of things to think about when it comes to term, even though it generally doesn't seem that important. And then it's also tied into termination. So how does this contract end? I always want to look for termination for convenience. So for example, if I see a contract that has a 3-year term, but it doesn't have a termination for convenience period, well, that could mean that you can't leave before the end of that term without having a claim from the employer for damages. for coverage for you. Most contracts do have termination for convenience. A lot of times at this level, they are in, I would say 60 to 90 is really the standard, but you'll see some as short as 30 and some as long as 180 days. And that's how much notice either one or both parties have to provide before they can terminate the contract. And other things you'll want to think about, particularly if it doesn't have a termination for convenience provision, is are there penalties, for example, if you want to end the initial term early? So again, one of those other red flag terms, the same really red flag term to think about is liquidated damages. So if you decide that you want to leave your employment early, some contracts will say that you'll have to pay liquidated damages of a certain amount in order to do so. So those are things that you should definitely keep an eye out for. The next is, what are for cause? How can the employer terminate you for cause? So the advantage for the employer of terminating you for cause is generally it's immediate. And so we want to make sure that the reasons that they can terminate you for cause are reasonable and that you generally have an opportunity to get notice of those things and to fix the problem. Now, most of the time, these are big ticket items like you've lost your license to practice, you've committed a felony, you've stolen money from the company. But usually down is, it's usually a 10-item list, and down towards item 8 or 9, they get a little bit objective. You haven't followed our policies. And so normally what I'm looking for is to keep those really subjective and smaller ticket items out of the immediate termination for cause bucket. The next one is, I think, really been incorporated in a lot more physician employment agreements because of COVID, and it's the force majeure provision. I do a lot of commercial contracts, and force majeure has been something that they have included for a long time. So what they say is, if there's some reason that I can't perform my obligations for something out of my control, there's an earthquake, there's a riot, there's certain actions by the government, I don't have to perform. Before COVID, I don't think I ever saw a force majeure provision in a physician employment agreement, but I am seeing them way more regularly. And again, it was for the reason that a lot of practices felt like they didn't have flexibility when they didn't have as many elective surgeries, for example. So that's definitely something that you want to take a look at and be aware of. And that I would put force majeure on my list of red flag items to make sure to talk about if you see it in an agreement. And I think we already talked about liquidated damages and repayment obligations. I'm just going to keep going through, and then I can answer any questions at the end of this sort of other items section. A lot of things that I talk about with my clients is the other things that they'd like to see memorialized in their contracts. We always try to get, especially where you're working for a bigger practice group, we always want to have the employment agreement, where possible, list the locations where you are working, so that you're not surprised where they tell you that you're only going to be working at one location, and then once you end up there, you've got to go to 5 different locations that are 20 miles apart. Usually we'll put in language that says, these are my primary locations, but I will go to other locations upon my mutual agreement. And that's usually a win, but that's something we definitely want to talk about. Some practices are really reluctant to put that information because they want the flexibility. We want the opposite. The next thing is schedule. Some agreements will say what the expected schedule will be if you've got clinic hours during a certain amount of time, and some will not. So usually, at least in the initial phase of negotiations, we're going to try to push to have some additional detail on schedule in there. And maybe this gets back, I think, a little bit to the general comments on how we negotiate. Generally, I want to see everything that I would like to see in my employment agreement. When you have a contract, after you sign it, legally, it speaks for itself. So if a court at some point has to interpret the contract when you've got a dispute, it's not going to look at emails that they sent you. It generally is not going to be interested in conversations that you had. So as many things as I can get into the agreement as I can, I will. My second step is to try to get things in an email so that at least maybe a court won't look at it, but at some point down the line, towards the end of your employment, if you have a disagreement, you can point to the email that says, well, you told me this. Again, not legally always enforceable, but something that I'd prefer to have. And then the last thing is verbal commitments. I really tend to really push for something in writing wherever I can get it. Call coverage is obviously really important because that dictates what your life is going to be. So there's a couple different key phrases that you'll see with respect to call coverage. The first one is the one we like the least, which is call schedule as determined by the employer. We really try to get something a little bit better than that. The next step, we think, the next best would be at least to identify that call schedules will be on an equitable basis. So all of the physicians are taking the same call. That still has some openness to manipulation, but it's better than as determined by the employer. The last and really what I think the gold standard is trying to get maximum on your calls. So if you've talked to them about having 14 call shifts, let's try to get them to write that in the contract. Or something nice we've gotten in some circumstances where the physician really had a concern about call being excessive based on what they know about the practice. We've written in things that requires the employer to provide locums if call is exceeding a certain number of shifts. So those are some things to think about and what we try to push for in call coverage language. Benefits are going to be a big part of this. A lot of times I will not, I'll do some of it. I'll make sure that what is in the contract aligns with what you've agreed to. But then looking into the benefits is generally, the physician getting comfortable with what's been presented. Some physicians are going to be interested in outside work provisions. So most contracts are going to provide a restriction on any kind of work outside of the work that you provide for the practice. If you really want to moonlight, or if you want to provide certain types of voluntary services, let's talk about that in the front end and get a written agreement that you can do that if that's important to you. And then intellectual property, I would say probably about half the agreements I look at have intellectual property provisions that basically give the employer the intellectual property that's developed during your employment. There is a small set of physicians that are really, really interested in this. A lot don't particularly care, but if it's something that's important to you, it's something that you should definitely look at in order to carve out things that are going to be your intellectual property and not property of the employer. So those are the items that I wanted to talk about today. Eileen, I don't know, do you have any other questions in the chat?
Nothing in the chat right now. So if anyone has a question, feel free just to shout it out or put it in the chat for us.
All right, well, I appreciate everyone.
Oh, you know what? One just came through. How long can the negotiation period take place?
Yeah, it really does. It depends on who's on the other side of the table. I would say it generally takes a few months from the letter of intent stage to actually signing the agreement. It's usually longer than you think. We generally turn them quickly, but if you're dealing, for example, with a hospital system, there's bureaucracy that things have to go through in order to get approved. So I would say a few months is generally the timeline.
Here's another one. To work with you, should we just send you an email?
Yeah, of course. Eileen, was my information on the materials or my email?
You know what, I'm not sure. So for everyone that's on here today, you'll get an email from me just following up and thanking you for attending, and I'll make sure that Rebecca's contact info is in there.
Yeah, if you're interested in working with me, just reach out and I can give you information, particularly if you're in the, we have some information on how our contract negotiation process works, as well as what the resident fellow program is that we run.
We've got another question. After accepting an offer for a job that will start after 6 months, it says, if I change the plan and want to proceed with another job, will there be an issue?
And is this not the lawyer answer? Like, it depends. It's crafted differently in certain agreements on when things start. So for example, in some agreements, the non-compete starts from the minute you sign your agreement, and in others, it doesn't start until you actually start working. So it'll depend on the language of your agreement. I mean, my advice to people is generally don't sign the agreement unless you're certain about it. I know things do come up, and people have to change, but it really, the consequences will depend on, what that actual agreement says.
Okay, one more question. Which of these terms do you find hard to negotiate with academic institutions in particular?
I mean, academic tend to be challenging, particularly the larger academics, because they are very large. They really like consistency in their agreements, and they are generally challenging on everything. Particularly, I think for them, I think their salary structure is less negotiable when it comes to an academic. The academic tends to have a different structure too. A lot of the times with academics, you're going to have multiple agreements. So you'll have one agreement that relates to your teaching position and one that relates to your clinical work. So they're kind of unique agreements for academic, and they're a little bit less standard, I would say, than a general hospital practice agreement is.
Any other questions? We've got one more. Is something like IP really negotiable with a university setting? Are there ways around it?
Generally, it's going to be tough for things that you develop in your employment with them. A lot of the things that I have had success negotiating are work that you do outside of work. So some of the language is so broad that it would take in any IP that you develop during the time of your employment, whether you're using your employer's resources or not, whether you're doing it on your own time or not. I have been successful in getting that carve out. You're right, it is challenging to negotiate for your own IP that you've developed during your work time with the employer's resources. That's often a pretty tough argument. Can we get them all?
Okay, so this is, I think, going with the same question. It says there is no non-compete. The only mentioned thing is 60 days notice prior to leaving the job. But I'm talking more professional wise. Is that okay? Or is it a huge mistake not to take a job after signing a contract?
Is it a huge mistake professionally not to take a job after you sign the contract? Probably outside of my area of expertise. I don't know how someone would know. From my perspective, it really is what are the legal implications. I probably couldn't speak to professional ramifications of that.
Any other questions?
All right, well, thank you all so much for listening to my presentation. And thank you for inviting me, Eileen, and the County Medical Society.
Of course. Thanks so much, Rebecca. And like I said, everyone, just look out for an email from me, just following up, providing some contact information, and keep an eye on your email for our next event in this series. And thank you so much for attending.
Great, thank you.
All right. Have a good night, everyone. Yes, we will send this recording out as well. Thank you.